What happens if the police accuse you of trespassing? That's exactly what we'll discuss today. Let's get started.
A man is standing outside his apartment building. He lives there, has lived there for 2 years. A security guard walks over, looks at him and says, "You don't belong here." 40 minutes later, he is in the back of a police car. Not because he did anything wrong, because someone decided he looked like he didn't belong. That story is not hypothetical. Versions of it happen across this country every single week. And the terrifying part is not the security guard. The terrifying part is that the law gave that security guard the power to do exactly what they did. Here is what most people walking around America believe. They believe trespassing means breaking in, a fence, a locked gate, a no entry sign. They believe if they are just standing somewhere, a parking lot, a lobby, a public-facing building entrance, they're fine. They believe the worst that can happen is someone asks them to leave, and they leave, and that is the end of it. Here is what the law actually says. In most US states, trespass does not require a fence. It does not require a lock. It does not require a sign. It requires a thing. Notice, once someone with authority over that property tells you to leave, even once, even verbally, even months ago, that notice is legally binding. If you come back, you are not in a gray area. You're committing a crime. And here's the question that should be sitting in your chest right now. How many places have you been told to leave, even casually, even as a joke, even in a disagreement, and then gone back too? Because under the law in most of this country, that return was a criminal act. Let's walk through exactly what that looks like in real life. There is a quiet assumption that most people carry into a shopping mall. You feel confident there. You are a customer or a potential customer. You're spending money or you might spend money. You believe that makes you welcome. Here is what the law actually says about that mall. It is private property. The owner, or any employee acting as the owner's agent, has the legal authority to tell you to leave for any reason that is not explicitly prohibited by law. If they do and you stay, you can be arrested in most states without any further warning. In Texas, under Texas Penal Code Section 30.05, criminal trespass requires only that the person received notice and failed to depart. Notice includes a verbal communication from someone with apparent authority. That is the entire threshold. You do not have to argue. You do not have to resist. You just have to still be there. Now here is where it gets uncomfortable, because malls have exercised this authority not based on behavior, but based on appearance. In 2021, the ACLU documented multiple incidents across Michigan and Ohio where black teenagers were removed from mall properties under trespass policies. Not for doing anything, but because security guards made judgment calls about who looked like they belonged. When those teenagers returned, because they were teenagers and it was a mall and it was somewhere to go, some of them were arrested, not cited, arrested. Under criminal trespass statutes, that is fully legal. The law does not ask why you were removed. It only asks whether you were told to leave. If a security guard approaches you in any private commercial space and begins a removal process, the words to say immediately are these: "I'm leaving now. I need your name and your employer's name for my records." Then leave immediately. Do not argue. Do not ask why. Do not stand your ground. The moment you decide to assert your right to be there is the moment the clock starts on your arrest. Now let's go somewhere most people think they are completely safe. Your own front yard, your own doorstep, your own apartment building's parking lot. This is where the assumption becomes most dangerous. People believe that owning or renting a space gives them absolute protection from trespass law, that they are the authority, that they cannot be trespassed on their own property. Here is the legal reality. If you live in an apartment complex, the outdoor common areas, the parking lot, the courtyard, the mailbox area, the hallways are often not your property. They are controlled by the landlord or the property management company, which means the property management company can ban you from those spaces, and in some documented cases has. In 2019, a tenant in Charlotte, North Carolina was served a no trespass notice by his own property manager for the common areas of his own apartment complex during a lease dispute. His apartment was on the 6th floor. He could not get to the elevator without crossing spaces he was legally barred from entering. The case eventually reached a settlement, but for weeks he was technically at risk of criminal trespass charges walking to his own home. The statute that enabled that situation is North Carolina General Statute 14-159.12, criminal trespass in the first degree. It applies to any person who enters or remains on the premises of another after being forbidden to do so. The law does not ask whether you pay rent there. It asks whether someone with legal control of that specific space told you not to be there. This is the thing that should reorganize everything you think about renting in America. Your lease gives you the right to occupy your unit. It does not necessarily give you the right to every inch of the property you pay to live on. The moment you get into a conflict with your landlord, you are one no trespass notice away from a criminal charge in a building you still pay rent for. If you ever receive any communication telling you that you are not welcome anywhere on a property where you live, the first call you make is to a tenant's rights attorney, not back to the landlord. Not a negotiation call, an attorney call. Because the document that comes next could determine whether going home is a criminal act. Let's talk about what happens the moment police actually show up. Not mall security, not a property manager, an officer. You're standing somewhere and someone called, and now there is a uniform in front of you. Most people believe the right move is to explain. To say, I live here, I'm allowed to be here, let me show you my ID and explain the situation. They believe explaining will make it stop. Here is what explaining often does instead. It gives the officer more information to work with, not in your favor and theirs. Anything you say in that moment about why you are there, where you came from, who you know, what you were doing is a statement that can be used to contradict you later if the case proceeds. Under the Fourth Amendment, an officer can temporarily detain you if they have reasonable articulable suspicion that a crime has occurred or is occurring. A trespass complaint from a property owner is by itself enough to establish that suspicion in most jurisdictions. So when the officer arrives and you are still on that property, the suspicion threshold is already met. What you say from that point forward is either neutral or harmful. There is no version of explaining that makes this faster. Invoking your right to remain silent and asking whether you are free to leave, those are the only two moves with predictable outcomes. Say exactly this, officer, am I being detained or am I free to leave? If the answer is you are free to leave, leave. If the answer is you are being detained, say I'm exercising my right to remain silent, I'd like an attorney, then stop talking. Not because you are guilty, because the law does not reward innocent people for talking. It rewards them for saying nothing and letting the absence of evidence do the work. Now let's talk about what happens in the gray zone, the places where the law and real life diverge so far they barely resemble each other. What happens to tourists? A visitor from outside the United States does not have a mental map of which spaces are private and which are public. In many countries, a publicly accessible entrance to a commercial building is effectively public space. In the United States, it is almost always private. That distinction is invisible on the ground. There is no sign that says you are now subject to removal at will. In 2018, 2 men tourists from the United Kingdom were removed from a Disney Springs shopping area in Orlando under trespass provisions after an altercation with a security contractor. They were not aware that the outdoor retail plaza, despite being open to anyone and freely accessible, was entirely private property with its own trespass enforcement infrastructure. They returned the next day, not understanding the significance of what had happened. Both were arrested under Florida Statute 810.09, trespass on property other than structure or conveyance. The charges were later reduced, but the arrests were valid. The law had been correctly applied. They just did not know what law they were in. Now here is where the written law and the real law split apart completely. On paper, trespass enforcement in the United States is supposed to be content neutral, meaning the reason you were told to leave should not matter. Behavior is the trigger. The removal stands regardless of whether it was fair. In practice, research from the Stanford Open Policing Project, published in 2019, found that trespass-related stops and arrests occur at dramatically different rates by race in American cities, even controlling for neighborhood demographics. The gap between what the law says it is doing and what it is actually doing is not subtle, it is structural, and the mechanism that makes it legal is simple. The property owner's subjectivity is the law. They decide who belongs. The statute just enforces that decision. The case that changed everything on this topic in recent American legal history happened not in a courthouse, but in a Starbucks. In April 2018 in Philadelphia, 2 black men, Rashawn Nelson and Dante Robinson, sat in a Starbucks waiting for a business associate. They had not ordered anything. They were waiting. The manager called police. Both men were arrested for trespassing. The footage went everywhere. The public response triggered a national conversation. It led to a policy change at Starbucks. The company closed over 8,000 stores for a day of racial bias training, and a settlement with the city of Philadelphia. But here is what changed illegally and what did not. The trespass statute was not changed. The arrest was not found to be unlawful. The manager had the legal authority to call police. The police had the legal authority to arrest. The law worked exactly as designed. What changed was corporate policy, not law, which means tomorrow in a different Starbucks with a different manager and no camera, it can happen again, legally. And here is the loophole that almost no one knows. In several US states, if you are trespassed from a property and the property subsequently changes ownership, the no trespass notice does not automatically transfer to the new owner. In states including California and New York, a trespass notice is generally tied to the specific owner or authorized party who issued it. New owner, new authority. Legally, the original notice may be invalid. This means in some circumstances, a legally binding ban on your entering a property disappears the moment that property is sold. Now, here's the thing that changes the entire picture. The thing nobody says out loud. Trespass law in America is not primarily a safety law. It is a control law. The legal mechanism it is built on notice plus presence has nothing to do with harm, intent, damage, or danger. It is purely about whose permission you have to occupy a physical space. And in a country where property ownership is deeply unequal, the map of who can be removed from where looks exactly like the map of who owns what. This is not an accident. This is the architecture of the law doing what it was designed to do. When you understand that the mall arrests the apartment notices the Starbucks moment, they are not aberrations. They are the system operating correctly. And knowing that is the only protection you actually have. Here are 3 things to hold on to. First, if you are ever told to leave any private property by anyone claiming authority, leave immediately. Get the name of the person who told you and document the time and location. Do not debate, do not delay, do not test it. The record you create in that moment is the only thing standing between you and a criminal charge. Second, if you rent and you have any conflict escalating with your landlord or property management, call a tenant's rights attorney before it reaches a verbal or written removal notice. The notice changes your legal reality the moment it is issued. Prevention is the only reliable option. Third, if police arrive and someone has claimed you are trespassing, do not explain, do not prove you belong, do not offer context. Say, am I being detained or am I free to leave? Then I'm exercising my right to remain silent, ID like an attorney. That is the entire script. Every word beyond that script is a risk. If this changed the way you think about physical space in America, about who actually owns the ground you walk on, and who is allowed to decide whether you belong there, the book I would send you to next is Chokehold by Paul Butler. He is a former federal prosecutor turned law professor, and he wrote the book that nobody in his former office wanted written. Chapter 4 specifically walks through how low-level charges function, not as responses to harm, but as tools of spatial exclusion. He names the mechanism, the history, and the way it feels from inside a courtroom when you watch it work. Find the link in the description top of the box. Here's the question I want you to sit with. Think of one specific place you have been told you were not welcome, maybe years ago. Maybe it felt minor. Maybe you brushed it off. Have you been back? Not hypothetically, specifically, because depending on where that was and what state you were in and who said it, you may have committed a crime and simply never been caught. What does it tell us about a legal system when millions of people are technically guilty of something and have no idea? The law does not care whether you knew. It only cares whether you were there. If this changed how you see something, there is more. Subscribe.
That's all for this video. For more information, watch these videos.